So take this as a scenario and work out for yourself what you think is fair or not. A Westpac worker who helps process mortgages was allowed to work from home after she'd had a child. This arrangement lasted for several years. But under new CEO Anthony Miller, Westpac ordered all workers into the office at least 2 days a week. The woman took her employer, Westpac, to the Fair Work Commission, alleging the order was unfair. She'd moved further away from the office. The Fair Work Commission, in a landmark judgment, agreed with the woman. The finance sector union now says it will target more banks and finance companies on the exact same issue.
In our view, this case is very important because what this shows is that where an employee has a real specific need to work from home, in the case of our member, Carleen, it was because of her childcare responsibilities and the fact that she had been successfully working from home for a number of years. That was more important than Westpac's general desire to have people working in the office a couple of days a week.
So let's bring in here George Haros, a partner at the law firm Gadens. He specialises in employment and industrial relations law. Many thanks for your time here on the program. I know this is not the first case. There was another one involving a Metcash employee just a little while ago. So there's a number of these coming through the Fair Work Commission. But from a legal point of view, does it mean employers now have to be very careful in the way in which they write, say, workplace contracts or agreements, and indeed individual contracts with workers?
Well, thanks very much for having me, Ross. And employers need to be particularly vigilant and careful at the moment in the manner in which they do write their contracts and their policies. But look, this is not a new area of law. The ability for employees to make flexible work requests has been enshrined in Australian law for a long time. It's probably just that working from home and flexible work requirements and flexibility is such a big talking point in Australian workforces at the moment that this is another case that's just shining a very bright light on this particular area of law.
Isn't the issue here, though, not necessarily the flexibility of the working arrangement? It's the ordering of those workers to come back to the office at least a couple of days per week.
Well, it is. It's a factual scenario here that's very specific to the case in question, obviously. And as in all cases like this, you just have to consider those facts in each scenario. But what's happened here, obviously, is you've had a long-standing employee with that flexibility and then a change in position, and it just demonstrates the importance of complying with the Fair Work Act and the specific requirements under the Act when responding to these flexible work requests.
So there's employers around the country watching this program. They're the business leaders. I'm sitting here and wondering what can they do to protect themselves against this type of action in the Fair Work Commission?
Yes, well, the Fair Work Act does have a number of requirements when responding to a request to work from home. And businesses should be extremely thoughtful in responding, both in terms of the process, the timeframe to respond, which is a strict deadline, and also ensuring that they provide adequate business reasons as to why the flexible work request should not be granted in each scenario. So dealing with those in each situation, really considering the business and operational needs and ensuring these are thoughtfully considered and put in writing. Also, if there's any temporary provision for working from home or some flexibility given during a certain scenario for an employee, that it's clearly documented as to why that flexibility has been provided at any point in time so that it can't then be used in the future by that employee for a more fulsome or lengthy flexible request.
So would the suggestion by the Victorian Premier, Jacinta Allan, to basically introduce legislation that would make working from home a legal right for Victorian employees, would that make any difference to this whole scenario?
The Premier, after this decision, may in fact wanted to try and seek more than 2 days, in fact. But look, they're quite different scenarios. In the decision that we're discussing, that's a federal decision of the Fair Work Commission, as opposed to the Premier's proposed legislation for Victorian workers. So it's hard to correlate them. But I will say that this issue of returning to work or flexible work still seems to be one of the hottest issues in employment law in Australia. It's also one of the hottest dinner table discussion topics. And, it's taking a lot of time to find its natural balance and will be continued to be debated in Parliament. It'll be continued to be litigated in the Commission and other courts and tribunals. And, it is taking a long time to settle following COVID and that really big period of people starting to work from home.
There's no doubt about that. I'll tell you what, it's great to have in the program today George Haros, a partner at the law firm Gadens. Many thanks for your time.
Thanks, Ross.